Joining us now is Jessica Mason Pieklo. She is the Vice President for Law and the Courts at RH Reality Check, which I believe is rhrealitycheck.org or .com. She'll tell us. She's a writer and adjunct law professor in Boulder, Colorado, and she is here to talk to us about what's going on with reproductive rights and the Supreme Court. So, Jessica, thanks for joining us.
Thank you so much for having me.
So, first of all, I guess let's start with this. We have a court case going on in right now, Whole Women's Health, Texas, the Texas case. Why don't you just give us, if you would, a quick background on what the case is and what they're talking about with the Supreme Court here. We've covered it before, but just to quickly put our conversation in context.
Sure. So some of your listeners and viewers may remember the marathon filibuster by then Texas State Senator Wendy Davis over a series of what had been previously failed bills, but eventually got passed that we call HB2. And HB2 is an omnibus bill, so it has a whole bunch of different parts, but they all relate to abortion. And two specific provisions in that bill were up in argument before the Supreme Court yesterday. One is a requirement that mandates that abortion providers, the doctors performing abortions in the state, have admitting privileges at a hospital within 30 miles of the clinic they're performing the abortion at. The second is a requirement that abortion clinics meet the same standalone architectural requirements as ambulatory surgical centers, even if those are clinics that perform no surgical procedures at all. So those are requirements that, for example, say the hallways need to be about 8 feet wide instead of 3 feet wide to fit a surgical gurney. Those were the issues that the Supreme Court heard arguments on yesterday.
So the short version is they are laws intended to make it so expensive to provide these services that really a lot of, maybe eventually all non-hospital institutions will be unable to afford providing them, right?
Absolutely. I mean, I think one way to look at the central issue of the case is it possible under the law for states to regulate out of existence abortion clinics within their borders while still having Roe on the books?
Right. And one of the things you've said, and by the way, it's rhrealitycheck.org, I'll correct myself there. One of the things you've written there is that in a way, this is a 36-year-old case emerging again. What do you mean? What do you mean by that?
Well, so in the days and months leading up to yesterday's argument, a lot of the media attention, and myself included, has been on the court's previous big marquee abortion case, Planned Parenthood v. Casey. And that was a 93 decision that gave us the undue burden standard. That was the only decision that Justice Anthony Kennedy has ever voted in favor of abortion rights in, and it is the decision that is considered to be sort of the great compromise in abortion rights. Since Casey, though, states have gotten very good and very creative at the ways in which they roll back abortion rights and access under the undue burden standard. So that's part of it. Oh, yeah. So then the second part of that is that really, though, these are laws that disproportionately impact and, I will argue, target poor women, women who are immigrants, maybe undocumented. This is designed to attack the rights of the most vulnerable. And we have precedent for that through the Hyde Amendment and the Supreme Court decision in Harris v. McRae that upheld the Hyde Amendment. And for your listeners or viewers that don't know, the Hyde Amendment is appropriations measure that bans the use of public funds for abortions except in very limited circumstances. So if you are a woman and you are on Medicaid, the chances of you being able to use your Medicaid to get an abortion are pretty slim.
So in a sense, is it fair to say that what the Roberts Court is doing here is relitigating what we had thought were settled rights?
Oh, absolutely. And I think that the anti-choice movement has been very clear since the ink was not even dry on Roe that they plan to relitigate abortion rights until they can get a decision in their favor.
Okay, so here we are, Jessica Mason Pieklo of RH Reality Check. Here we are. This case has been taken up. This is just the fact that the Supreme Court took it in a way was probably a battle in the war to roll back reproductive rights. But now they've taken it. We had on Wednesday, there were conversations about it in the court. So what's the latest?
Well, okay, so there are a couple different moving parts here. One is, as you guys are all probably aware, we have an incomplete court, right? We only have 8 justices right now with the death a few weeks ago of Justice Antonin Scalia. So one issue that the court is trying to figure out is this a case that they want to decide on the merits, so actually resolve whether or not these restrictions are or are not constitutional without a full court. And that's a political decision. That's not a legal decision. That's just they have to decide that for their own. So that's one piece that I think is important. Another piece that is important is the fact that the Fifth Circuit is in an active fight with the state of Louisiana over very similar, if not nearly identical, restrictions that were recently enacted in that state. Should they be allowed to take effect, and the Fifth Circuit most recently said that they thought they should, that would leave Louisiana with only one abortion clinic. Providers have filed an emergency appeal with the Supreme Court asking them to block the Fifth Circuit order, and that response from attorneys from Louisiana was due to the Supreme Court yesterday at 3 p.m., I believe. So that is going on in the background. And if it wasn't enough, there is still one more case from the Fifth Circuit involving these kinds of trap regulations, and that's out of Mississippi. Mississippi is another state that only has one abortion clinic, and lawmakers there passed admitting privileges requirements. And the Fifth Circuit ruled in that case that they could not take effect because they would shut the state's only clinic. So the court right now has 3 different cases from 3 different states that come to 3 different conclusions. The Fifth Circuit made a mess, and the Supreme Court is going to eventually have to take it up. Procedurally, what happens next is on Friday, the justices get together in an informal conference and cast their initial votes. That doesn't mean that we are anywhere close to finding out what those are, but that's the process. And then once they see where the votes go, they begin that process of divvying up for opinions or, maybe fighting it out and voting again. But that next sort of consideration phase happens on Friday.
And for some of our listeners who might not know, we are recording this on Thursday, so but you may be hearing it on a Saturday if you are listening to the program. So we may or may not get the answer after they have that informal vote. Is that going to be publicized?
No, they rarely are, if ever. The only way we would find out something really soon, I think, is if the justices are tied 4-4 and they want to get rid of the case and send it back down to the Fifth Circuit. In that case, it's possible that they could issue an order quickly after Friday's conference.
So, okay, so the choices, I guess, and again, when we're talking to Jessica Mason Pieklo of RH Reality Check about the Supreme Court and its newest abortion rights case. I mean, I'm struggling. It's complicated. There's so many moving parts in this, but I guess as I understand it, correct me where I'm wrong, we're looking at 3 possible outcomes now that we have Antonin Scalia has passed away, so we have a court that could be divided evenly. We could have a decision in favor of the state of Texas, which would eliminate these rights in that state. We could have a decision against Texas, or we could have no decision and it's sent back to a lower court, but you have these other situations in Mississippi and Louisiana left unresolved, right?
That's correct. That's a really good summary.
Oh, good. Okay. I am so pleased when I get something like that right. It doesn't always happen. And let me ask you, Jessica, while I have you, I also... This is a court that, it seems to me, has taken an activist, judicial activist approach. I know conservatives hate it when conservative judicial activism is called judicial activism because that's an epithet they like to reserve for supposedly liberal judges upholding the Constitution. That's my editorial comment. But this seems to me to be an activist court when it comes to reproductive rights. It's taking a lot of cases. And isn't there another one coming up later this month having to do with, well, you tell me.
Yes, well, to your first point, is with the Roberts Court being activists and taking up a lot of reproductive rights cases. I think that that's true. I also think that part of it is the natural litigation cycle that we are seeing play out from the first wave of anti-abortion restrictions that were passed in post the 2010 election. But what we're going to have and what we're going to see in 2 weeks is another fight over the Affordable Care Act. Conservatives have been litigating the Affordable Care Act since its passage, and on the 23rd, the Supreme Court is going to hear arguments in the case of Zubik v. Burwell, and whether or not the Obama administration's accommodation process for those organizations that claim to have a religious objective to complying with the law and providing contraceptive coverage through their employee health care plans, if that process is unduly burdensome to their rights under the Federal Religious Freedom Restoration Act.
Right, which is, and we've had historian Kathleen Friedel on and other people to talk about that. This entire notion of corporations having religious rights, to me, seems, well, you're an attorney, you're a law professor. It seems bizarre at best to say that a corporation, which is a legal and financial entity, can have a religious objection to participating in the Affordable Care Act. Isn't that the essence of the argument?
It is. Your reader or your listeners and viewers may remember the Hobby Lobby case, and this is the extension of that. The idea and what effectively these groups are arguing for is not just that they shouldn't be able to or shouldn't be forced to, from their perspective, provide and comply with the law, but that nobody should, that their employees or their students who are on these plans, if it's at a religiously affiliated college or university, that they should not be able to access it, because it is the very act of even trying to access it that puts these institutions, as they say, complicit in the sin of contraception.
So, again, forgive me for stuttering, Jessica Mason Pieklo, but it's just so outside the realm of what I consider rational thought, frankly. That, and I suppose that may not be what this is all about. But so they're basically saying that if it's a religious institution of higher learning, for example, that students should not be allowed to independently access the Affordable Care Act and obtain coverage that may include some form of contraception?
It's the argument is that those students should not be able to access the contraception under the Affordable Care Act. So normally what would happen is these institutions would raise their objection. The government would say, okay, fine. We will work with a third party then to fill in the gaps of coverage between you, the objecting institution who provides the health and the employee health insurance, and the third party provider, the insurance company. So what the nonprofits are arguing is that even that connection that the government makes between the student or employee who needs insurance for contraception and the insurance company itself, that is a process that should be blocked.
Yeah. Okay. So that they're going to take up that case. The Shakers who objected to. I'm not anti-religion, but the Shakers were against sex in any form. Which is one reason why there are no more Shakers anymore. But so theoretically, if there were a Shaker institution of higher learning, they could object to providing Viagra, right? I mean, that's.
Yeah, and I think it's important too to distinguish between religious institutions, like churches who are already exempt from all of these coverage requirements anyway, and religiously affiliated nonprofits. Those are hospitals, those are nursing homes, those are universities, those are places where. Those are places where people of all faith or no faith go for services, go, to school. And the idea that the First Amendment and the idea of religious freedom in particular is being weaponized here, I think is something that should give this country great pause.
Right, especially since every hospital in this country has to have a certificate of need from the government and receives government funding
Mm-hmm.
and all of that. That if they're going to receive those privileges, and yet be exempt from certain honoring certain parts of a national law. Well, it's all very troubling and all very complex. And I hope at some point you will come back on the program and update us about what continues to happen with these issues at the Supreme Court.
Oh, me too. I just would like to make one other point just to
Sure.
really connect the dots for the listeners, since you brought up the Hyde Amendment and with the abortion case to bring this full circle. I think it's really important with the birth control challenge to remember who is most impacted by these restrictions. We're talking about students, we're talking about low wage workers, and so that this is very much an extension of the rights war on the poor that we see.
Right. Oh, absolutely. Because of the poor are the ones not able to travel out of state, for example, or do some of
Hmm.
the. So there's no question about that. And thanks for making that final point, Jessica Mason Pieklo of RH Reality Check. And thanks for coming on the program.
Always a pleasure. Thanks so much for
All right.
having me.